Wednesday Zoom and Learn that we hold each Wednesday at 12:30. We're grateful that you took the time out of your day to join us and hopefully learn some stuff today. Today we have our guest speaker, which is Mary Jane Morris with Granite Escrow, and she is going to be walking us through EMDs and pretty much start to finish, the good, the bad, and the ugly. Hopefully you will take some takeaway from today of something that you did not realize or know. So without further ado, I will pass the mic on over to you, Mary Jane, and if you want to kick us off, that'd be awesome.
Can you hear me okay?
Yes.
Hi, good morning, good afternoon, everybody. I'm Mary Jane. I'm the Vice President of Sales for Granite Escrow. I'm Annie's partner, for about 30 years, Annie and I have been doing escrow in various places together, and she lured me back to escrow, and so here I am. I am a retired escrow in 2000, and I retired from brokering about 2 years ago. Next month will be my 40th anniversary in real estate. I got started in my parents' office, so I've done a little bit of everything. So today I wanted to talk to you about some things you will know and some things you won't know about EMDs. So we're going to jump right in, and one of the key points that I promised you was to talk about the kinds of mistakes that you want to avoid with an EMD, and some are pretty standard for you guys. Having more than 3% of the sales price in escrow at any time is not a good idea. Obviously, we try to keep those deposits reasonable, but not artificially low or artificially high. I didn't know if you also knew that the 3.0% of the deposit is limited to owner-occupied. Investors are not subject to any limit whatsoever. So if an investor throws a $50,000 deposit on something that the math doesn't work on, that is a liquidatable. So if it's a non-owner-occupied investor property and not a owner-occupied property, the deposit can be any amount and be liquidated. And at any time, this is a conversation, so at any time, jump in. Tommy's been helping me a little bit with getting used to sharing my screen and all, so let me know if you guys need me. You have a question. Another big thing that agents don't know that they should avoid doing is increasing your own EMD on page 1 of the residential purchase agreement. When you increase your own deposit on page 1, it makes it liquidatable, 100% liquidatable from day 1. If a listing agent counters you and asks for an increase in the deposit, only the amount on page 1 is liquidatable, not the entire deposit that they asked for. It is a very common rookie mistake, even for listing agents, and it's when you should, when you're on the listing side, be sure to include the RID form and bring that deposit in as part of the liquidatable amounts if that's what you intended it to be. Another thing that I want to talk to you about, and this one's pretty common, especially in the age when everybody's working from home and hardly anyone goes to the office, and there's less and less of the big 5 type offices where they have a log book and you would hand over the checks that your client gave you. If you're touching money at all, you are in danger. You should not be touching checks. And since there is no reason, we don't need to send a copy of the check anymore with your purchase agreement, there is no reason you should be touching money at all. If you do have to touch money, there is a single page on CAR, a single transaction trust fund log sheet, 1 page that you can bring into your transaction to show that you logged it in and what you did with it and logged it out. And this will meet the requirement if you touch money. But in general, I prefer you just give them if they're going to send a check, give them an envelope with a stamp, or encourage wires, or picking it, having them drop it off at escrow. But you definitely don't want to be touching money. Just get in the habit of just hands off. This one doesn't happen much anymore, but post-dated checks or promissory notes, we see those every now and then. Somebody will throw, the older school realtors will throw something like that in, or delay sending in the EMD. So You want to keep your eye on those first 3 days. Annie has a very interesting policy. Annie, did you want to tell him when you open escrow?
I'm sorry, I was doing something else. Tell them what now?
How you handle making sure the deposit gets in when they open escrow with you.
Oh, when they open escrow with us, we have a system set up that, you know, they need to have the checks in within 3 days. So on the second day, if the check isn't in, we will let the parties know, just send out a little standard thing that says, just to let everybody know, we still haven't received the wire and or check for deposit.
And then your escrow instructions.
We don't send our escrow instructions out until we actually have the deposit. Most of my agents already know that. I say it in the very beginning when I first send the welcome email, also just to remind everybody, but that way they know for sure that the deposit's in.
One of the most common things that I talk to VA borrowers on when I'm signing loan docs when I was an escrow officer was that they anticipated getting the exact amount of the deposit returned to them in a check. Those deposits often get eaten up in part of their down payment or closing costs, and especially since they're low amounts, usually around $1,000. I want to remind you that when you put 100% on a RPA and it puts it in parentheses, it creates the impression that they're going to get that money back in a check, and it very rarely happens. So I wanted to make sure you guys know that VAs are told that they are going to, that money is most likely going to be absorbed. I have seen recently that lenders will cut a check if they go into it knowing that. But most of the time, I just wanted you to know that I spend time as an escrow officer explaining why they're not getting that money back. And since you're often not in the room, it makes me feel like I'm guarding your reputation. And so I just thought maybe we could manage that expectation a little better. Any questions so far? Otherwise, I'll move on.
Yeah, and guys, if you do have any questions as we're going along, you can always throw them in the chat as well, and I will see them there, and we can answer them as they come in.
We've been getting a lot of questions as how much is enough EMD in this market. The reasonable stuff that too little, your offer's not taken seriously. It's going to make us look twice as hard at your proof of funds. Even VA loans these days, we were very surprised to find this year that investor sellers were insisting that the veteran have more skin in the game in the deposit. So having them too little can be a problem. Also too much. This is a broker's nightmare. Occasionally, a client will say because of the difficulty or because he's so confident that he will want to deposit the entire amount that he has to put in day one or halfway through the transaction or something. You can't get that money back without a signature if the transaction cancels. They don't have a right to it in the liquidated damages, but they can hold it up so that escrow can't release it without a signature. So you don't want to have too much money in your transaction ever. They can hold it up and negotiate it right till you finally agree to cave, or they take it to small claims and they are able to max out the 3% through some lucky, breaks through getting the right judge or being able to say the right thing that day. So we definitely don't want too much money in the escrow. The seller, another risk is the seller may think the buyer doesn't need money for repairs or any of that. You may show your hand that you've indicated that this client has plenty of money, and that is not the point when it comes to a repair or something that the seller should take responsibility for. So you definitely don't want to have too much money in the transaction. Another great use for the EMD that I have to recommend all the time as a broker is our fundamental position is don't lose anybody's money. Never ever lose that deposit. Never ever release it. That is basically our go-to position, which is absolutely correct most of the time. But in COP transactions, I recommend 20 times a year that you start releasing the deposit to buy time for extensions or to buy possession. Occasionally we wind up with a senior citizen or somebody who's down on their luck. and they literally cannot move into their apartment or whatever unless they had a little bit of moving money. And so in those cases, that's a great time to, especially if you have a lot of confidence in your transaction, and your buyer's well qualified, then to buy possession and get what you need done is a great way to. And my favorite thing about doing this is if you successfully close, it didn't cost you one dime extra. You just had an extra tool in your belt to encourage negotiations to go the way you want them to go. I went on to say to buy agreements of any sort, something to get the termite work going, because you're not going to be, you're willing to risk the $1,500 for the termite work while your loan gets approved, because otherwise everybody's not going to be done on time. So your EMD can be used for that. The other one I wanted to mention was to avoid agent participation, meaning out of your pocket expenses, something that nobody else seems to have a solution for, when we could have used the deposit to maybe grease the wheels a little bit instead of passing a bill outside of escrow or to a party whose bill it isn't, like yours. I did put a warning down at the bottom that if your transaction was not good and strong in the first place, it's not good or strong in the second place. So if your deal is solid and your client agrees to this is an excellent way to use your EMD with no additional expense. Per diems are an additional expense and often can only be paid by the agent because the CD has gone out and the truth in lending is all done. So I would prefer to grease the wheels with the existing money, especially if you're close to or you've already released contingencies. At that point, I like to drip it out and try to hang on to some of it, but it could easily grease your wheels.
I want to add something there that everybody needs to understand, that when you do an early release of funds, then it's a really good idea to, let's say you've got 10 grand in there and you've decided to release the 10 grand. Many times I will see that the agents have decided, okay, well, we're going to release the 10 grand, seller can have that, but we want another 5,000 put in. So they still put more money back into the file.
I have heard, I've had that tried on me many times. I don't think I've actually had to get that far, because usually we're so far along in the transaction, but that is a possibility. The one that you should look out for, and I did check with Annie before I spoke for Granite today, but 50% of the escrow companies out there require a notary on the pre-release amendment. And it isn't because they're going to record it. They want it to be a space in time where you understood you released this money and that escrow may not be able to get it back for you, because that is the risk once it's released. That's why you want to release it in portions if you can. But if your escrow company is going to require a notary and you think you solved the problem and there's a lot of pressure, it could take 1 to 3 to 5 days to get the notary, to get the addendum out, the notary done, and it back to the escrow officer on both sides before it can be released. And the reason I mention that is because it can work for you and it can work against you. So occasionally when I was brokering, somebody would call and tell me they were on one side of a transaction or the other, and that they had been asked to pre-release. And I would ask them to quietly find out if the notary was if the escrow company was going to require a notary. If they do, it's going to get you some free time that you might not wind up ever releasing that deposit. On the other hand, in our case, we don't require a notary. We require a live signature, and so we can move a lot faster. So you just have to remember which side of the transaction you're on when you are arranging a pre-release. If it can't happen quickly, it's no benefit to the seller. So when I personally use this technique in a counter, I already call my escrow company and get their language and put it in there as well. But most people wouldn't think to do that. So please remember, a pre-release requires not only agreement, but an escrow amendment, because escrow has to cover themselves that they will not be able to get that money back from you and the liability to be released. These are all standard and normal things. And if you know what you're doing, you can manage that risk very easily.
And just to clarify, Granite Escrow does not require those early releases to be notarized, but we do require wet signatures.
Right. And I believe those can be faxed or emailed back as well. They don't have to be as original.
That's true. Yes, that's true.
we just want to make sure everybody's very clear. And I personally prefer this because I can get that much quicker than the notary. But if you don't remember that piece of it, you may agree to something that you never see. So keep in mind which side you're on when you're making those arrangements. I wanted to talk about when a transaction is canceling. Most of us have been through this. I will tell you, and Annie will attest to it, that in 10,000 closings or 10,000 cancellations I've seen in my career, 99.95% of them release at some point.
Mary Jane, you froze there. So we're waiting for MJ to come back. If anybody has any questions in regards to anything, please use the chat function.
Very clear. When
All right, so we lost MJ. Whoops.
Oops, she's back. But she's on mute.
All right, so
I'm here.
There you go.
Mary Jane, your connection got so weak we lost you. So why don't you go ahead and reshare there?
Can you see my slide?
No, you're gonna have to reshare it. So bottom of your screen there, you have to, if it says you're sharing, you have to click on stop sharing and then reshare
It
it.
doesn't say I'm sharing. So this is that part I worried you guys about, that I don't know how to do this easily myself.
Okay, so you're gonna, let's see, bottom of your screen, you're gonna see that little Zoom recording button as an icon on your desktop.
I'm in presentation mode. I think I need to come out of presentation mode.
Hit escape. Come out of presentation mode.
Here we go. All right.
So click on the Zoom meeting again icon on your desktop bottom. It looks like a blue box with a recorder in it. Pull up the Zoom meeting and then you can go back to sharing.
And share. And here I am. And share. Am I back?
You are back now. Just hit presentation mode, the bottom right-hand corner icon.
I'm not going to do that again. We can just do it from here.
Okay.
So makes it easier for the boomer at this point. So if your chat, I don't know where I left off, but if I did you hear me?
Start over on this slide.
All right. In Annie's and my experience, we must have seen 10,000 cancellations each. About 99% of them do release sometime by agreement. So early in the transaction, when I'm speaking to a buyer, I make sure I make the speech that there are only two ways that deposit is going anywhere: mutual agreement or act of law. I'm going to move this where I can see it, not be looking sideways at you. All right, so mutual agreement or act of law. Those are the only two ways a deposit is going to be released from escrow. When a listing agent is screaming at me that he's going to this, that, and the other, I am very confident that that deposit is going nowhere until we have mutual agreement or act of law. And there is no other solution. Now, CAR did try to work with the Escrow Association and provide a way for when a client disappears that we're able to serve that form that CAR has. I can't think of the name of it this second, but the seller demand to release or the buyer demand to release the deposit. They can, and you should, because it's a procedure that's available to us. You can give that to the escrow companies, and if the other party goes silent for 10 business days, the escrow company has a chance to release that deposit. However, again, immediately 50% of the companies said, oh, heck no. And definitely in COVID cancellations, nobody is taking that risk whatsoever. And what's our policy on accepting the seller demand?
Right now, we're not taking it.
Yeah, there's almost no way.
No, we haven't been since March. There's just too much with the COVID stuff. You have to be careful that there's not something that has to do with that we're not aware of.
This next little piece is the thing that I thought this whole conversation that I've given you up to here was to teach you this little piece right here. In every arbitration and mediation agreement in a regular standard car contract, there are exceptions. At the very bottom of the mediation and arb clause, there is a bold paragraph that says this, and it says these are the things that are excluded from mediation and arbitration: foreclosure, things to do with mortgages and install sales, unlawful detainers, and any matter that's within the jurisdiction of probate or small claims court. So when an agent is at that point lost his cool and starting to be belligerent with me, and they start threatening me with arbitration and mediation, I tell them, no, you'll never get me to arbitration. I will have you in small claims in 30 days. So plus service, when you go to file a small claims, they give a few days for service, but you basically get a court date in 30 days. So
Even right now with the COVID?
no, I was just about to go on with that. So
Oh.
with the courts closed right now, I have a stack of these that I'm helping get through for my last brokerage. There are 8 at least deposits where, but it isn't because somebody doesn't, it's literally because an agent doesn't understand the rules and thinks that they are going to be able to get the deposit by holding up and taking us to small claims court. However, the reason I want you to know this is you never again have to take guff from somebody who's threatening your deposit if it's less than $10,000 for an individual or less than $5,000 for a corporation. Corporations are the ones that fall through this hole the most because they usually have huge deposits and they exceed the limit. I just had a really good COVID case where the buyer was a corporation and lost her entire down payment in the stock market the same week that we all got sent home in March. And the seller is determined to hold on until we can get it to all the way to small claims court. When I reminded them that our buyer was a corporation and was even the amount that they had was they couldn't exceed more than $5,000. Basically, their heads came off, and they're just determined to take us there. So we'll go there. But I want you to be very confident. And I have a whole other class I teach called How to Win at Small Claims. In the course of our escrow business, escrow gets named because people don't know what we really do. We get named occasionally, and we have to go down there and be excused. And while we're sitting there, we often get to hear quite a bit of it, or we have to give an explanation on why we handled something in particular. So we sit in a lot of small claims cases that have nothing to do with us. In my years as a managing broker or an actual broker, I also sat through many of these, and I have got it down to a science. And so I don't want you to feel bullied by people who, or if they throw the arbitration mediation clause at you. If your amount fits in small claims, that's where it's going. And by the way, many of these people have, did I pause again?
No, you're good.
Okay. Many of these people have, are just convinced that you can't talk them out of what they're thinking. So you wind up having to wait. So we've got a stack of these waiting to go. But the attorney, they'll take it to their attorney, by the way. That's what lost my train of thought. So they'll take it to the attorney, and as bad as they would like the attorney to write us a letter, the attorney will tell them immediately this is small claims court territory. So sometimes when somebody threatens me with a lawyer, I will ask them if I could speak to them quicker. So instead of avoiding the lawyer, can I speak to the lawyer? So because very often I can get the lawyer to understand what's in writing better than I can get the emotional client or the emotional agent to understand. So I just wanted you guys to really have a good grasp that if it is under $10,000, you can take it to small claims. And then let's talk about the benefits of small claims versus mediation and arbitration. The speed of the settlement, 30 days plus service. The entire cost is about $150, including service to each party. Often, as the broker or the agent, I will offer for us to pay on your behalf for my agents to pay that because it just makes us look great. Mediation is very expensive. It's been a couple years since I've been, but at the time it was between $500 and $650 just to sign up, and then about that per hour per side, however long it took you. So you eat up that deposit way faster than would be the benefit of waiting for it. And you also have to agree on a mediator and all that sort of stuff. So the small claims court is your best bet. It creates the active law that escrow can release the EMD whether or not one party agrees, and usually once the court has spoken, one party is not happy, and they actually create a judgment that escrow can use to actually release the deposit. This is one of my best parts right here for your protection, for agents' protections. It's between the seller and the buyer. It's not the agents unless they get named. Excuse me. The way that I keep you from being named and the way I would advise you when you call me and you have these situations is that's the best thing about being back in escrow for me now. I can talk to anybody I want. I'm not a broker anymore. Keep by helping the client know their rights, helping them, even if we have to pay the $150, provide a nice, beautiful copy of the file. You can be standing on the right side of the courthouse instead of the side that gets sued and you have to explain your behavior. So it is in your best interest to stay with a client, keep those relationships up, even as I've gotten more Yelp reviews for saving a mess than I've ever gotten for a perfect closing. So don't forget that those are opportunities to be amazing as well. They're not opportunities to get paid, unfortunately, but they are opportunities to be amazing. There are some limits you should know. No more than $10,000 for individuals can be granted even if you win. They will allow you to appear in small claims court even if you put 30, 40, 50, $100,000 on there. It's just the first words out of the judge's mouth is he can't grant you any more than 10, and $5,000 for a corporation. We're in the middle of the COVID-19 delays. John Giardinelli, and I always worry that I say his name correctly, our former board attorney and good longtime friend in the Temecula Valley, has made it very clear that small claims will be about dead last in the reopenings of the courts. He believes it's that the criminal, of course, and then tenant, and then bankruptcy, and then small claims is going to be the order that it goes in when we are in a position of opening the courtrooms again. The biggest problem, and this one wins me, this is in my How to Win in Small Claims Court, is being afraid to appear before a judge. If you have that fear, you may have to take it seriously. If you understand that, I always joke because, you know, some of us boomers are old enough to remember the People's Court, but this is literally the People's Court. And this is a place where you can go and be a little bit scattered and a little bit, my advice is not to be more scattered than the other guy, because the way I prep you, you look calm, cool, collected, and all your exhibits are numbered and you're not digging through anything and you're not crying. And I honestly believe more than half of my wins have been just by looking to be the sensible person in the courtroom. The other thing I want to tell you, if you don't have a winning case, don't take it to small claims. If the full CR was removed and no COVID-19 conditions apply, or the CR was never released and he's trying to keep the deposit anyway, or you flat don't have evidence for your COVID claim, you need to make these decisions before you take a position that you can't back out of. So try to make sure that you've done your research and that you put your ducks in a row. And then once you do that, you'll be able to speak with total confidence when someone is angry, upset, or abusive. You can't have more than 2 cases a year exceeding $2,500, but that's for the individuals that are filing, meaning it is unlikely that the seller or buyer is going to have more than 2 cases a year. No matter how many you have to participate in, as long as your name's not on them, you can't sue for more than $2,500 twice a year. There are some other drawbacks that I didn't name here. The usual stuff, your clients not presentable for court, or literally cannot go to court for some reason. They insist on pressing a non-winning case, something like that. So there's some other drawbacks that factor into it, but most of the time, what I've just taught you will walk you all the way to settlement, whether it's today or down the road a little bit.
Okay, so a question came in on the chat.
Yeah.
From Antoine. It said, can a seller hold on to the EMD even though they canceled with the first seller and entered another escrow with a new buyer?
As long as they move the escrow. California escrow does not allow an escrow company to close with two transactions in the same company. So simply move the escrow to another place and you may continue your argument. You may continue your argument for however long it takes to settle it. So if you're on the listing side and you're using your favorite escrow officer, like we hope you are, sometimes you do have to go to your second favorite. And if you're on the buyer side, yes, they can continue selling the house once the cancellation is signed. But please remember that the cancellation form has two parts. The top half is who canceled. And we can talk about that again some other time. And then the bottom half just simply says what happened to the deposit. So that argument can go on, and the seller could have long closed his house. I hope that.
Just to add to that, let me just add to that. So escrow has, or our escrow company has an instruction that we send out on a cancellation that all parties agree that the file has canceled and that granted escrow will be holding the funds until mutual agreement or litigation mitigation, some type of litigation of some type. So we have an instruction that we can send out, and that way we can actually cancel the file and it becomes a holding of the money only. And then we can take the deal back.
Gotcha. And Mary Jane, let's take this back one step.
Yeah.
Because, and Antoine, if you want to unmute and pipe in, you can.
Yeah.
But let's say that we were within the 17-day inspection contingency period and it cancels, versus already have released contingencies and something goes south and the transaction doesn't close and it cancels. What would be the difference?
I hear two different questions there. One question, the first part of that question applied to that particular transaction and where it was in that particular transaction. The second part was whether they could move that escrow or create into a holding escrow. So I'd like to answer the question he'd like to actually answer. Do you want to talk about exactly where your transaction was at that moment?
Well, ultimately, there's only one question here. It says, can the seller hold the EMD? That's the question. Even though they canceled with that seller and entered a new escrow with a new buyer.
Yes, they can. And they, not because they're going to win it. And I guess that's why I was trying to say, if you want to talk about the particulars of that transaction, when people refuse to release, it's almost never because of the rules. It's because they're pissed. They're angry. They're not going to let you get away with that. So yes, they can. Should they have? No.
Right. And I guess my question was, an additional question in regards to this was, if it's within the contingency periods in the front end and the buyer cancels, and does the seller have a right to hold it, or do they need to immediately release it, versus if it canceled because of something that happened after contingency removals have already taken place, right?
Right. So when I occasionally have an agent or a client that's determined to take a case to small claims, even when the contingencies haven't been released, I won't even go stand there, because they are a slam dunk, positively will not win. So I won't even go stand there with you. That's one of those times where I'm saying, if you don't have a winning hand, don't go there. So if the contingencies have not been released, regardless of what day we are on that transaction, that deposit is to be returned. Yes?
Correct.
Right. Now, will they is a whole nother conversation, which is why we have these little classes.
Right,
They,
so that's why they might have to either get the holding escrow like we do, or go to another escrow to be able to sell.
right. So here's what your duties are as a broker and or an agent in a transaction. You need to tell your broker, if you have one, that you've got one that's about to go off the rails, and not the initial conversations, everybody's just annoyed, but if it's truly going to be a problem, your broker needs to know. They may be able to bring some common sense or a cold bucket of water or something to the situation that'll help you let them be bad cop and you can be good cop, for lack of another term. Please advise your clients of their right to seek legal counsel. Again, another fear of realtors is anything having to do with a lawyer, I don't want anything to do with it. You should advise them of their right to seek counsel, because just like I told you, they're going to come to the same conclusions. They do not have to arbitrate for under certain amounts. They are going to have to take it to small claims. And yes, I have occasionally gotten a letter from an attorney who was being asked to convince us by pressure to release the deposit. I'm still going to give the same answer. As long as the client does not wish to release, we're going to continue this conversation until we get to small claims court. So I want you to have the power of that. And especially with granted escrow, and now, especially now that I'm out of brokering and totally back into escrow, you can call me about any transaction you have going on, whether or not it's my deal, because I'm going to literally lay things in your hands that are going to be provable. I'm not going to put a wish in your hand. I'm going to actually give you the paragraphs and the exact sentences you need to say. So advise your clients of their right to seek legal counsel and document it. Hey, Annie, so sorry that deposit's going south. I wanted to remind you that you have a right to legal counsel. Move on. But it doesn't have to be a formal. It's just something to protect you. Be ready to provide your records immediately, meaning if you're not a person who uses a transaction coordinator or keeps things easily handleable, this is a time to pull your file together and make sure that you're ready to give copies of files and emails and texts and things that they will need to hopefully negotiate before we have to take it to small claims. Otherwise, what you're beginning to do is create these small claims courts by collecting exhibits. These are just good broker advice for the next is not the to keep communication high. Even if you're a jerk, I'm going to pick up your call. Even if you want to talk to me 7 times, doesn't mean I'm going to change my position. I think that refusing to speak is often the most common reason that we wind up in small claims court. We didn't put enough effort in the communication, even when it was difficult. This one I put in just for me. You must do your fiduciary duty to the bitter end. You did not get a commission, but it does not end your responsibility to assist the client in the EMD settlement. One of very common comment I would get from younger or newer agents is, I'm done with him. I'm never speaking to him again. And I would have to say, yes, you are, or I would take over at that point doing all the communication if I really had that problem. But even though you sort of, for those around who were around in the short sale market, you didn't always get paid, but you had to close. So your fiduciary duty does include the return of the deposit. So don't take a position that makes your own job harder.
Hey, I have a question for you, Mary Jane. So let's say that they're one side or the other, I guess it doesn't really matter, but one side or the other, the agent has just walked away. They're done. They're not having anything to do with them, and neither is the broker. What about the agent, the other agent then? Can that agent help to, by speaking to the buyer or seller? In other words, if you represent the seller and the buyer's agent left and this is a cancellation and the seller wants the money and it's past the 17 days, so now they're trying to figure out how they're going to do this, whether they're going to split it, give it all to them, whatever. And the other agent's like, I'm not getting any money, so I'm gone. Can the seller's agent kind of jump in and start talking to the buyer and trying to get this thing worked out?
Well, we're all advised to avoid that as much as possible. And if you do it, you must document it. And at that point, I almost always tell them that I'm going to only be able to talk to you by email because I can't have one word of communication go back and forth that's not documented. So that, for one, is a broker role, but if that broker is not available, of course, you could continue the conversation if you were invited to, and you and they pick up the phone and speak to you, and you document those calls so that you're not in danger of revealing something like the guy never had the down payment in the first place, or accidentally say something that would hurt
might mess it up. Because as an escrow holder, I'm going to tell you, we actually get a call from one of the clients saying, my agent's nowhere to be found. Can I just talk to the other side? And of course, my response is, no, I can't give you that information. I can't help you with that. But as an escrow holder, am I giving them wrong information? Should I tell them, well, here's the other side's agent's name and number, and let them do that?
I don't know what, if from an escrow perspective, we would want to do that, but you could certainly advise them to reach out. Yeah.
Okay. All right. I just thought, sorry, I wanted to ask from an escrow standpoint.
I think we could probably have an entire Wednesday Zoom and Learn in regards to small claims and arbitration.
Oh, for sure. Absolutely.
Right? Just arbitration versus small claims type of thing. That would answer a lot of these, because I think we could probably go on for another hour in regards to situations that either somebody has been in the middle of and kind of found a way to either get it closed or it canceled and they walked away, but then always had that thought in the back of their head, like, I wonder what would have happened if it would have went this way, right? Or that way. Mary Jane, we did have one more question that came in.
Sure.
And I think it's kind of like a piggyback almost off of the previous question, but it says, if the seller closes with another escrow and they clearly are wrong for holding the buyer's deposit, can they also be subject to punitive damages?
Small claims does not grant a day's work of pay, costs of filing, punitive damages of any sort. Every loss has to be approved with a receipt or a clear, it has to be proved. So my general answer to that is no. However, I do want to answer the question that I'm going to get next, which is, in the contract, there is built in a threat of a $1,000 penalty, which I do claim when I help you guys file it. It has never been granted in my entire career. I have never seen them give the additional $1,000 ever. And the reason generally is that the judge feels that, however misguided, that person legitimately believed that they had a case. So I've never seen it granted, but I do threaten the $1,000 that's in the RPA when I am attempting to negotiate a settlement.
Okay, and so then I have a question as well. From a seller's side perspective, okay? And the buyer is unable to perform, and the seller cancels the buyer. It's after contingency periods have been removed, and the seller says, no, I've given you extension after extension. You still can't close it. I'm canceling you, and I'm keeping the deposit. I'm moving on to the next.
You have served your your demand to close escrow and waited out your 3 days, including if it lands on a weekend into the next business day.
Correct.
But then you're right back where you started. Yes, so yes, but then you have to still have the conversation with how you're going to get the signatures.
Correct. Now let's say that the seller's not willing to release the deposit. The buyer feels, well, you canceled me. I should get my deposit back. I'm trying everything I can to close, but they've given them time after time, because we've seen this a handful of times, right? And the seller cancels them, and the seller refuses to sign a release and says, no, contingency periods were removed. I've given you extensions. I'm not giving you another one. I've given you demand to close. You didn't close in those 3 business days. We're done.
If I was on the seller side and you called me with that call, I'd say you have a slam dunk. Threaten them and let's close small claims.
If you're on the seller side, you're like, yeah, even if they want to, because the buyer's going to say, okay, we're going to arbitration, and the seller's going to say, no, we can go to small claims.
Correct.
Right.
Correct.
But
Yeah, very,
ultimately, it's up to the buyer to pursue that, correct?
yep, yep.
And if the buyer pursues arbitration, the seller doesn't have to agree to it.
Nope, and it's an exemption anyway, and when they try to, when the arbitrator looks at it, he's gonna say, you haven't exhausted your capability to collect yet, and your option was to go to small claims, and you didn't take that up yet, so it's not a good use of your, and it's, you should decline and go straight to small claims.
Gotcha. Thank you.
Right. I wanted to mention that as you guys know, I've been teaming up with Annie and with Tommy, and every week, as soon as we're done with this class, we ask ourselves what's next. So we would love to hear if there's specific things you would like to know. And I will write you a class for them, and it can be done individually. It can be done in your office space. It can be done for just your team. It can be done with your client if necessary, so they understand the rights, so that I can help you look good. But please let us know what you would like to hear from us, because every week we try to come up with something we think is really valuable.
Yeah, and I mean, EMD over the last 2 weeks, it's just been a topic of conversation. So it was a good fit. But yes, we want your guys' feedback. If there's something that you feel has come up numerous times that you just feel you don't have all the answers for, that could be a perfect topic for a Zoom and Learn that we could put together. So share your thoughts with us, and we'll be more than happy to help.
That's just about it for me. Anybody else, any last questions? Or I'm going to put my phone number in the chat box. I'm also easily findable on Facebook. You can message me through there. And hit me with your toughest questions. I'm here for you.
Or you can always get a hold of me, and I will give you all her information.
Or as I. So,
Yeah.
all right. Well, Mary Jane, we appreciate you taking the time to go through this with us. Again, guys, if you have any additional one-on-one questions or what have you, you could direct it through us. Go direct to Mary Jane. If you need help, go through us, and we'll definitely put you in contact. Until then, we have a week between now and our next Zoom and Learn, which will be next Wednesday at 12:30. And we would definitely like some feedback in regards to what you feel would be a good topic. So please feel free to send that to us. We'd be greatly appreciated.
I think that's it then.
All right, guys. Well, thank you for your time, and we will see you next week.
Thank
Thank you
you.
very much.